Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Welcome back to International Law Behind the Headlines. I'm Catherine Amirfar, and in today's episode, I'm really so happy to be welcoming Sean Murphy, known to many of you as leading academic in the field of public international law. He's the professor of international law at George Washington University and also, obviously, the former president of ASIL. Among other distinguished positions, he's a former member of the UN International Law Commission, where he served as Special Rapporteur on the topic of crimes against humanity. Sean, welcome. Really happy to have you.
Thank you, Catherine. I'm delighted to be here.
So for our listeners, Sean, I'm just going to do some table setting, and then we'll launch right into it. So the International Law Commission, or ILC, is a body of experts tasked with codifying and progressively developing international law, although, Sean, as you well know, sometimes there's some debate about exactly what that mandate encompasses. But at the bottom, the ILC produces, among other things, draft articles that states can use as the basis for treaty negotiations. And Sean, obviously, during the time that you served as Special Rapporteur, you led the development of draft articles on that topic, which, following a very recent vote of the General Assembly, very excitingly will be used to negotiate a global convention, which is now slated for 2027 and 2028. So I want to start a bit with some of the historical context with you, Sean, and ask you the question about the ILC process itself. So the ILC's draft articles on prevention and punishment of crimes against humanity remained in the Sixth Committee, the legal committee of the General Assembly, for 5 years before Resolution 79-122 was adopted, and by which states finally agreed to move ahead with the formal negotiations for convention. Can you speak to the process the Sixth Committee took in considering the draft articles? I'd love if you could, looking back, tell us what stands out in your mind as the key moments in terms of both commonality and divergence of views. And for fear of overloading you, what would you say was the single greatest challenge in getting to consensus?
Well, I suppose the story starts with the 2019 ILC report, which contained the draft articles and the commentary, as well as a recommendation that states elaborate a convention on the basis of the draft articles. That was sent forward to the Sixth Committee, the legal committee of the General Assembly, in August of 2019, and they met in October of that year to discuss the draft articles and the recommendation. I would say right from the start, there was pretty strong support for moving forward with a negotiation, but there were states that were not sure about it, and certainly in the fall of 2019, there wasn't much time for states to take a decision and to get instructions from capitals and so on. So they decided to roll it over to the fall of 2020. That's all fine and good, but of course then the pandemic hits in 2020, and there's not really any in-person meetings happening in New York, so they basically have to roll it over again to 2021. At that point, the pandemic is less significant, but it's still a factor, so it slows down the process of taking a decision, rolled over again to 2022. Now, at this point, the pandemic's kind of behind us. A lot of states say they want to move forward, but there is a minority of states that are still resistant to the idea of launching negotiations. So that results in the fall of 2022 and the decision to hold 2 one-week sessions, resume sessions of the Sixth Committee, which happen in April of 2023 and April of 2024. The basic idea was not to negotiate the draft articles, but to find out what are the problems if they're there, and how might those issues be resolved among states. So coming out of the April 2024 resume session, you had a very large number of states that were ready to move forward, so much so that they produced a draft resolution that was ultimately co-sponsored by more than 90 states. that called for the launch of diplomatic negotiations. Over the summer of 2024 and into the fall, that draft resolution is being negotiated a bit, trying to bring on board more and more states. So much so that by the time you get to November of 2024, very strong sense that this thing is wanted by the states in the General Assembly in the Sixth Committee, except for a few states that were still resisting. So what was the real problem? The real problem, I think, at the heart is that the Sixth Committee has operated on the basis of consensus for a long time, such that you could have just one or two or three states resisting a decision to move forward. All of this crescendoed in November, on November 22nd, 2024, with the possibility that it would be taken to a vote, which would have been an extraordinary thing in the Sixth Committee. But ultimately, with a few last-minute changes, the naysayers were brought on board, and they were able, by consensus, to adopt Resolution 79/122 in November, which then went forward to the General Assembly as a whole and was adopted on December 12th.
That's really helpful, and I think for some more familiar with the ILC's work, notwithstanding, as you put it, the interruption of the pandemic, it's actually been remarkable to see how this progressed. And as you said, there was that moment in November 24. But at the same time, the resolution still, there's a pathway forward, right, Sean? So what I'm going to ask you to do is now look forward. How do you think the negotiation process will unfold under the resolution? And as I understand it, things will start to happen in early 26, but then may extend all the way to 29 and perhaps even beyond. So from your perspective, what do you think will unfold, and will you have a role in this process as the former special rapporteur on this topic?
A couple of the last minute changes that were made in November of 2024 were pushing out the timetable for the negotiations, and secondly, setting up a substantive preparatory committee. So where we're going from here is in early 2026, there will be a preparatory committee session lasting for 2 weeks to discuss possible amendments to the ILC's draft articles. Then states are given until April 30 of 2026 to formally send in amendments. So that first preparatory committee session is an opportunity to talk about, what amendments might be useful, what's helpful, why they might not be useful, and then for states to actually put them in. The following year, 2027, there will be a 1-week procedural session of the preparatory committee to settle on the procedures that will regulate the negotiations when they commence. But the diplomatic negotiations themselves will only begin in 2028, a 3-week session in early 28, another 3-week session in 2029. But you're right, there is the possibility of a third session if needed. Even after that, it'll be a question of whether, states have worked through whatever issues there are to work through.
Yeah.
In terms of my own role, the resolution that was adopted in December by the General Assembly requests the Secretary General to invite me to attend the substantive preparatory committee session and to attend the diplomatic negotiations as an expert. So I think what that means is I would be sitting up there on the dais with the chair, and to the extent that it's helpful for me to contribute to the conversation that states are having, I would do so, having had my experience as the special rapporteur at the ILC.
That's terrific, and certainly will, I'm sure, will be a value add in terms of bringing some continuity into the process. So let me ask you, and I want to focus for a moment on what you mentioned about suggested amendments to the draft articles, which you mentioned would be considered. Can you explain a bit more how they will be considered, what you expect their impact to be on the negotiation process? And I suspect one thing on listeners' minds will be, is that amendment process going to bring up some of the challenges, the points of concern that potentially may slow down negotiations? How do you see that unfolding?
Yeah, maybe the first thing to say is it's a little bit unusual to have this, meaning formal amendments being brought to the table before the diplomatic negotiations even commence.
Mm-hmm.
Usually you'd start the negotiation, maybe you'd have a zero text, and then in would come amendments. I think this was done because of a belief that states have been looking at these draft articles for a long time, not just since 2019, but since the process began even before that. And they do have ideas for ways the articles might be improved. And so they want an opportunity to have the diplomatic conference receive not just the draft articles and not just the ILC's commentary on those draft articles, but a compendium of amendments by states. My own feeling is this is a perfectly good thing. Indeed, I think it may aid the negotiations for states to be able to see potential amendments before they show up for the first negotiating session, think internally about whether they like it or don't like the amendment, so that they actually come to the conference with relatively well thought out views on what fixes, if any, they'd like to see. So it may well actually help speed up the process, and I think that's a good thing.
That's really helpful. So let me pivot for a moment, because I want to really put in context how truly momentous a prospective Crimes Against Humanity Convention would be in the fabric of international law. So let's pivot to some of the substantive considerations. Let me ask you how you think such a convention would complement the Rome Statute. And for our listeners, the Rome Statute, of course, established the International Criminal Court and enumerated crimes against humanity as one category of international crime. So for Sean, for you, what do you think would be the contribution of such a convention to the fabric of international criminal law when it comes to assuring criminal accountability?
Well, I think that the principal motivation of the ILC in moving forward with this project, and I think the principal reason why it's attracted a lot of support from states, is that it is attempting to fulfill a gap. That we have treaties that attempt to build up national laws and jurisdiction in a number of areas, whether you want to talk about genocide or war crimes or torture or so on. We don't have any such treaty in the context of crimes against humanity. So within that general fabric of international criminal law, we've got a pretty important international crime, crimes against humanity, but no global convention dedicated to building up national laws, national jurisdiction, and putting states in a cooperative relationship with each other on matters such as extradition and mutual legal assistance. So I think that's, in the big picture, what it's trying to do. There were concerns when we embarked on this. Well, how does it relate to the Rome Statute? And, the basic answer is the Rome Statute is creating an international organization designed to investigate and prosecute persons from The Hague. There's going to be limited capacity for it to do that. And it was always designed with the idea of complementarity, that in the first instance, it's a good thing to have national jurisdictions pursuing these crimes if they can do so. And if so, then the ICC would defer to them. So all the Crimes Against Humanity Convention would be attempting to do is to build up that national jurisdiction. And in that sense, it helps aid in the complementarity that the Rome Statute has in mind.
Thanks. That certainly makes sense in terms of as critical gap filler, if you will. I want to pick up on one of the threads that you mentioned and just probe a bit more. I think you mentioned that and genocide. And unlike the prohibition on genocide, which was codified in 1948, or the prohibition on war crimes, which was addressed in the 49 Geneva Conventions, I think it's notable that crimes against humanity has not yet been the subject of a global convention. Why is basically the question, Sean. Why is that? What's your view of what factors may have influenced this diverging history?
Yeah, it's a very good question. I suppose I'd observe that crimes against humanity were codified in the Nuremberg Charter. They were in the Tokyo Charter. Persons were prosecuted for them at those tribunals and so on. And in the aftermath of that, we did have some countries around the world adopt national laws on crimes against humanity that also allowed for prosecution of individuals who are alleged to have committed those crimes. You're right that there's no global convention that sort of systematically looks at crimes against humanity in terms of national law. We do have the Rome Statute, and it does deal with crimes against humanity for that particular international court. We also have a convention that most folks haven't focused on. It's from 1968. It's a convention on the non-applicability of statutory limitations to war crimes and crimes against humanity. So a rather narrow focus of that convention, and it actually only has about 56 states parties. So why no robust global convention on crimes against humanity? I think it's not entirely easy to say, but I guess I'd note this. Since the Second World War, we have had countries systematically attempting to develop treaties dealing with specific types of crimes, right? So torture, apartheid, enforced disappearance, terrorism, trafficking in persons, transnational organized crime, corruption, right? These kinds of things. And so there's been work done in the international criminal law space. They just haven't done this particular one. Now, one reason why maybe they haven't gotten to it until now is that when you think about it, crimes against humanity are essentially the large-scale commission of other types of crimes, right? So it's widespread or systematic attack in the form of, say, torture, or in the form of murder or enforced disappearance or so on. So maybe what we ultimately saw was a focus on addressing the more individualized crimes before getting to the point of addressing what happens if they are committed on a widespread or systematic basis.
Got it. Thank you. So let's do a deeper dive into some of the more controversial elements. And I want to focus first on the universal jurisdiction. So obviously there's an element devoted to universal jurisdiction in the draft articles, which would permit or require prosecution of atrocity crimes, regardless of where the crime took place, the nationality of the accused or the victim. And states, including Saudi Arabia, Ireland, the UK, have expressed concern about the potential for overlapping prosecutions or politically motivated prosecutions. Can you speak to these concerns and any predictions that you might have based on what I know has been fulsome discussions in the ILC context and thereafter about how such concerns might be resolved going forward in this process?
Yeah, that issue is often raised. I guess I'll start by noting that the actual term universal jurisdiction does not appear anywhere in the draft articles. And so much depends on what one means when one says that. As written, the draft articles do not provide for prosecution for crimes against humanity of a person with no connection whatsoever to the state engaged in the prosecution. Instead, the required bases for jurisdiction are that the crime occurred in your territory, your national is the alleged offender, or the alleged offender turns up in your territory. It also provides that if you wish, not required, but if you wish, you can exercise jurisdiction when your national is a victim of crimes against humanity. So I don't know if that's universal jurisdiction or not.
Well, there's contact with the state, right? And by virtue of that, then you are speaking to the underlying concerns about this notion of overlapping prosecutions, politically motivated. No, I understand.
Yeah, and I think it's really the same approach that you see in numerous global conventions that a lot of states have signed up to, such as the Convention Against Torture. It's really nothing new. We're just applying it now in the context of crimes against humanity.
That's right. And if I recall correctly, Sean, in the ILC process, I think that was one of the express points of discussion, right? That this is not novel, that this kind of language and obligation it certainly appears in other multilateral conventions, including CAT. Do I recall that correctly?
Yeah, absolutely. I mean, it would be going maybe too far to say that we just super copied an earlier treaty and scrubbed out.
I would never suggest such a thing, Sean.
Scrubbed out torture and put in crimes against humanity. But basically, we were attempting to just, replicate things that states, generally speaking, have already accepted, but to do it in this context.
No, and very wise to do so, of course. There, in the time that we have, let me just ask you one more question, and this is another point of I don't know if it's correct to call it concern, controversy, but certainly point of discussion. And that has to do around issues related to gender justice and accountability. So I note the calls, and this was really at a pretty relatively high volume in September, November of last year, Sean, about calls around formally recognizing gender apartheid as a crime against humanity. And there was certainly, and some have correlated the uptick in those calls by some states in particular, amidst a growing edicts targeting the freedoms of women and girls by the Taliban in Afghanistan. So that was kind of the confluence of circumstances in which this arose, but it certainly manifested in the process around this potential convention in the fall of last year. So the question is, how do you think the question itself of including an explicit reference to gender apartheid affected discussions in the Sixth Committee? How do you think it's going to impact the negotiations to come? What is the message to those that feel quite strongly about this formal recognition of gender apartheid in the convention as key to accountability and gender justice? Could you address that?
Sure. You're absolutely right that it was raised certainly by some states and even more so by a number of NGOs and so on. I guess I'll start by saying that the ILC decided to use the definition of crimes against humanity that appears essentially in Article 7 of the Rome Statute, and that has a lineage going back to the Nuremberg Charter. Why did it do that? I think the ILC saw value in using a contemporary definition of crimes against humanity that had already been accepted by a large number of states, rather than ourselves trying to negotiate a new one. Many states, when we rolled that out, thought it was the right choice. And I think even today, many states think that's the right choice. But you're absolutely correct that there are some states, certainly NGOs, that would like to see the definition altered. Some certainly are pushing the issue of gender apartheid, but there are other issues too. Ecocide is talked about, expanding the concept of what is persecution, what are the grounds for persecution, and so on. I mean, ultimately, it'd be up for the states to decide. I wouldn't say there was any consensus reached in the Sixth Committee, and one would have to see what unfolds in the negotiations. But maybe I'll offer just a few brief thoughts. First, the existing definition does embrace a wide range of acts. So I think the first issue to consider is something like gender apartheid implicitly already covered? So the issue of murder, enslavement, wrongful imprisonment, sexual violence against women, those are all already covered, as is persecution of women in connection with those acts, as is other inhumane acts of a similar character against women. Now, that may not get you all the way to what gender apartheid as a concept is seeking to cover. But I think the question is what's being left out exactly in light of what we already have. The second thought, and maybe I'll leave it at this, is that what this convention is trying to do is, in large part, alter national criminal law. It's kind of an intrusive thing. It's reaching into national legal systems in the criminal context to make changes. And I think one has to be very thoughtful about doing that. Presumably states are willing to go a certain distance, and one just has to, pause on whether if you try to do too much, it may result in some significant number of states not joining the convention at the end of the day. The convention does not prohibit any given state from adopting a wider definition of crimes against humanity. They can include whatever they want in their national law. What we're talking about is, what do we want the convention to compel a state to do? And I think, we just need to be thoughtful about there at some point being a line that one might cross that ultimately works to the disadvantage of a robust and widely adhered to convention.
No, that's right, Sean, and certainly prudent. And I will only note that, of course, I think that's not lost on the states and NGOs and other entities advocating for an express inclusion, but there's still a sense that it would be a grand omission to leave the concept of gender apartheid, which does have its own kind of, I would say, unique definition in the sense of what apartheid means, and then applying it on the basis of gender. But completely understood. But it sounds like at a minimum, we can expect that will be and continue to be part of the conversation going forward in the negotiation process. Is that fair?
Oh, absolutely. And I guess I'll just observe that when we were doing the final reading of the draft articles, we had more than 700 NGOs write in with a wide range of ideas for changing the definition. Gender apartheid was part of that, but there's a long list of things. Some, one might say are more important than others. I don't know, but there's no question that those issues will need to be confronted in the course of the negotiations and sorted out one way or the other.
Well, let me just on that note say a huge thanks to you, Sean. This has been kind of momentous, the developments last fall, and certainly I know that we'll be watching what happens going forward. So thank you so much for joining. Really appreciated having you here.
Well, it's my pleasure, Catherine. It's been a long road already to get this project moving along.
I know.
and the road still looks a bit long ahead of us, but it is moving, and I'm delighted to see that. And I'm sure that states are going to do the right thing and bring this to a successful completion. But thank you for having me on the podcast. It was a pleasure to be here.
No, the pleasure was all mine. And I will say that it's just nothing short of a miracle, some would say, that it's continuing thus far. So yes, it's been a road, but we're really a testament to your efforts and your expertise. So thanks.
Well, and a testament to the ILC too. I think I had the support of a lot of colleagues who were very committed to the project, and they are all over this project too. So it's not just me. And I think it's good for the ILC to see the General Assembly launch a negotiation relating to one of its topics. It's good for the institution of the ILC as a whole.
Absolutely. And in terms of fulfillment of its mandate. So with that, thank you, Sean.
Okay. My pleasure, Catherine. Take care.